You're listening to the Valley Current.
Take it forward. But in any event,
Dare to be 100. So let's talk about lawyers as negotiators, because, you know, business schools do teach courses in negotiation, but my recollection is law schools don't. And yet most of what lawyers do is negotiate. Many of them do it poorly, as we know, as I'm sure you've often seen from the big law firm point of view. They're kind of like unable to approach a problem as one that can be jointly solved at a negotiating table. And for my money, my general remark is the best negotiations that I've been in, people treat the problem as kind of the enemy and not each other as the enemy. The problem is the enemy, and they focus on figuring out brainstorming solutions. The current litigation is very much about treating the other side as the enemy, as opposed to treating the problem as the enemy. You could argue that that's fundamentally a flawed nature of the adversarial system, that the adversarial system builds in this antagonism that is against the grain of getting people together to commonly solve the problem in a brainstorming kind of joint exercise mode that looks at all the iterations that might produce a better and better outcome. I mean, that's really what happens in a negotiation, but many litigations don't start out with the view that there's going to be a negotiation, but we know that eventually, even after the trial, there's a negotiation. Even during an appeal, there's a negotiation. Even during, you know, after the appeal, even when the appeal is going on a further appeal, there's a negotiation. All the way to the U.S. Supreme Court, there can be a negotiation. So
right, and I would say,
that.
I would say this, that litigation, as we knew it when I started practicing, and even when you started practicing, was litigation in the court. You actually were able to get a trial date. You had a less complicated pretrial proceedings,
right,
fewer depositions, fewer meetings of discovery. It's all changed. So there you tried to resolve disputes through the litigation process, and if necessary, took it up on appeal. Nowadays, with the advent of social media, and as you well know, all the companies in Silicon Valley, all the Googles and the rest of them, everything has changed. So the litigation process might start the way it started, a little more sophisticated way now, by filing complaints and getting the litigation going. But sooner rather than later, you get the assistance of a professional mediator, Danny Weinstein, Ken Feinberg, these kinds of people. And they try to bring the two sides together and to assist. But the lawyers, yes, you're right. The lawyers are not trained to negotiate. They don't think in those terms, but they do rely on the mediators. So, and of course, as I mentioned before, the cases are bigger and bigger. The amounts to resolve them are greater. So in any event, so here's a negotiation. I asked him, did you have, or are you using mediators? Yes, they're using mediators. But these things don't take place in the court. And that's the other point I want to make too about your premise here. There was a time when you could resolve or attempt to resolve a civil case in the courts. You can't do that now. You can't do that because the criminal cases take priority, and there are so many of them, and the federal judges and the state court judges are into the criminal cases. And now, of course, with COVID, it set everything back. I don't know when. We were talking, I have weekly calls on my Plains case. That's the pipeline case down here, the oil spill. We were close to resolution in that case. When we had a trial date. We had a trial date scheduled in January, but of course we lost the trial date. The minute we lost the trial date, the resolution went down the drain. The mediators weren't able to do anything. The other side didn't want to settle, and they saw a field day. It's a Full Employment Act. So in any event, so getting back to what you're really asking about, yes, is the They don't teach negotiation in law school.
Right. I'm kind of reflecting on the fact that there are mediators means that lawyers are not functioning as good negotiators. They need help. Well,
they need help.
In the ideal world, the lawyers would be able to just go face to face across the table or across a Zoom screen and have a back and forth about, well, what if we did this and what if we did that? These days, there seems to be so much concern that if you give an inch, somehow you're going to be taken advantage of. There's a basic lack of trust that you could say breaks down the entire process, because years ago, many, many years ago, the lawyers kind of knew each other on a first name basis. Yeah. And you probably would run into them in the same bar, the same restaurant, the same cafe. You would just run into people, and you tried to have a civil, if not collegial, relationship. That's broken down as well. It doesn't seem that happens, except maybe if all the plaintiffs' lawyers get together, all the defense lawyers get together, and never the twain will interact with each other, which is unfortunate because it does create a basic distrust of, any plaintiff's lawyer has a ridiculous case. Any defense position is obviously an insurance company position. It kind of stereotypes everything. So I wonder how this is going to change, because there's only so many mediators to go around, and it's not that many people go into the profession to become a mediator. At least most people don't.
You said last night to our friend that it's almost innate. It's in certain people. There's only 5 probably really great ones.
Yeah.
Thousands.
Well, I'd say this. You're absolutely right. And yesterday when we were downstairs in our so-called Bell-Eye room, I was looking at some stuff, and there were photographs of Mel taken with Moses Lasky, who was the major litigator of Roebuck, Klager, and Harrison, sitting together having drinks, or Jack Sutro. Sutro at Pillsbury Madison, the Sutro. And I may have mentioned, he said to Mel one time, and Mel told me this story, Mel, I want to thank you for practicing, for opening up your firm, for being active and publicizing yourself, because you have brought more business to Pillsbury Madison Sutro than anyone else. It's like the lawyer who opens up in a little town in Grass Valley or something, or I did in Sonoma, and there's no business. But then another lawyer opens up across the street, and oh my God, you got so many cases going. It's fabulous.
Someone said to me, why are all the lawyers clustered together like in downtown San Francisco? I said, because they need to kind of fight each other nearby. I mean, it makes it more convenient to have the fight to some degree. But it's true even in the garment business, right? There's a garment section of Manhattan, these certain sections of the world. But do you think the law schools should change? Because the business schools got savvy about this years ago. And there are obviously a lot of business people that feel like the one thing they get out of an MBA program is they actually do some theoretical teaching about what makes for a good negotiation and what makes for being a good negotiator. And they wouldn't otherwise spend any time thinking about that.
Right. And I think that's right. Just this week, I had Zoom a meeting. I participated in the meeting of, it's like a board of trustees or whatever it is at the Columbia Law School. And I'm on that board, and with the dean and a bunch of other people from the university. And we talk about these issues. We talk about curriculum. We talk about, I always raise the question about endowment, because it's all, especially now, so much of what the school is using in terms of money comes from their endowment. So you want to be thinking about endowment. And this then plays into the question of admissions, because you want to still admit the students that are going to later be generous to the law school. And they come down to like one of two categories. The ones whose father went there, grandfather went there, so they're going to be there to be concerned about legacy and the continued existence of the school. And the other is, interestingly enough, people who are the C students. Susan talks about this all the time, how the C students are the most generous because they're so thrilled to have that degree and they're able to get through and they give back. The A students are federal judges don't make enough money.
Right.
And the B students, if they're not federal judges, maybe the university professor, they don't make enough money. So it's the average guys who went out there and worked harder. Yeah, worked harder and give back. So in any event, that's getting off the subject. But the fact of the matter is that they don't teach negotiation. And I'm thinking that I have a conversation with the dean one-on-one in a couple of weeks. And I'm thinking I'm going to discuss with her a possible further gift that I might make out of the big case we have and creating something. See, so Elizabeth was interested in this, and at Berkeley, she created out of one of the other cases she was doing this consumer center. I'm listening to you, and I'm thinking that some practical aspect to practicing law.
I think you should do something that allows the law students and the business students to take a class where they negotiate against each other. The law students will learn from the business students because the business students typically have been out for 7-8 years before they go to the business school. They don't let them into Columbia Business School unless they've had kind of a few years out in the field, but at least today, that's how they're doing admissions today. Years ago, it might have been different. But I think the business students versus the law students would teach each other something, because the law students get stuck into the mode of, well, your legal remedies are X, Y, and Z. Right. And the business students look at it, no, you got to look at this more orthogonally. We could do a trade, we could do this, we could do that. I mean, this idea of coupons that have become popular in settling class action cases, that has nothing to do with legal remedies. That came out of a creative idea by a business person saying, let's try to do something that's really smart here. The law of remedies is very broad. It's not going to constrain us, but it's not going to necessarily give us the idea for what's going to work.
The coupon idea was a good one, and it has been used many times now. And it's a way of bringing about a win-win. And I think you're right about this, the business schools graduates are more mindful of the fact that you want to create a win-win. And the law graduates are more concerned about winning on one side only. It's not a win-win. It's
right.
So what I try to do in my business, and when I get to discussing negotiate and its possible settlements, I want to fashion a win-win. One way to fashion a win-win is to give the company, like I mentioned, a case I had many years ago, it was about side saddle trucks, General Motors manufacturer, and they had side saddle meaning the gasoline tag. They stupidly put the gasoline tags on the side of the truck. Right. So if they had a collision to the side, the truck would blow up. So in any event, in the process of trying to get a settlement, we came up with the idea of coupons to get those bad trucks off the road, give the person the right to buy another General Motors product, not a Chrysler or a Ford product, and have coupons that were better than the average consumer could get. So they had two characteristics, the coupons. And we made this up. They had to be, one, transferable, so you could sell it to someone, and number two, stackable. So if they stackable, meaning if there were other benefits you could get. If you own 3 General Motors vehicles, you get 20% off, or whatever the hell it is.
Right.
That's stackable. So you could stack that with your coupon, and then it allowed us to have somebody create a company that handled the transferability. And you can do this all online now. It's very easy. Right. So I have a coupon for a truck. I don't want another truck, but I try to put it out there, and then it gets marketed, and I could get several $100 for it, and I sell my coupon. So in any event, but after we did that, we got subject to a lot of criticism because it was different. Whenever you do something different, people criticize. But I'm thinking of doing the same thing. I'm going to have this call on Tuesday, and I have mentioned it to my colleagues. That is to say, in the European Volkswagen, because in Europe, the orientation is different than here. They're not thinking about bringing a lawsuit and winning. They want to work things out more. They have some more socialist tendencies.
Right.
So in any event, yeah. So we're going to try to do that. But you're right. I mean, this whole idea of the negotiation process, would be improved if you could combine these two and the business school and the law school grad. And I think that what is happening, correct me if I'm wrong, but the big CPA firms, which is now down to maybe 4, used to be 8,
Right.
whatever it is, they now are getting into the law business. They have lawyers and they know how to do all this. And now the law firms are probably going to have business school graduates
Right.
working there.
Right.
So for people like you and for me, who had the foresight to get both degrees at a stage when people weren't doing this commonly, it's a great, awakening. It's an opportunity for everybody to.
Right. Do you think, Bob, your biggest asset that you bring to the table is you can hear things from a negotiating point of view that your colleagues just can't? In other words, your talent is you kind of hear the meta message that might be generated or being delivered by the other side. That is, there are very few lawyers that sometimes can capture the nuance of where a conversation is going. But I think there's some like yourself that can, and that produces a lot of value in the negotiation.
I think that is right. And I think in my case, it's for whatever reason, I always try to be fair. Fair in terms of handling people in my firm, fair in putting together law firms, fair in resolving disputes. So I try to be thinking about what the other side, what that company wants. And yeah, they want to sell their product mainly, but they also want peace. They don't want to be paying lawyers for the next 20 years. So that will permit me to come up with a solution. And then I'd like, in these cases, I always like to reach out to the executives at the company, getting past the lawyers. Now, it's not that easy because you say to the lawyers, well, bring your principal. Well, you could insist that if you have a mediation that you say, and I say this to the mediator, tell them to bring their number 1 guy or number 2 guy so that we could talk to these people so they could hear us even though they have their lawyers in the room. I want them to get the fact that we're going to be working something out with them. So, so thank you very much. And I think my experience in my age, in my personal history has allowed me to get into a situation where I could better see what's fair and what's just, and always, one last thing, and always be willing, and this is what I try to tell my lawyers, but it doesn't work, always be willing to leave some money on the table.
Well, you probably had that talent even above Belli, and my guess is you rescued Belli in a lot of cases where he couldn't negotiate a resolution, and you did, right?
Well, yes, I did. And I'd certainly say that he did not have this talent at all. He wanted to litigate. He wanted to fight. He wanted to get his name in the papers. He was not ever interested in finding a solution to a problem. That was not the way he functioned. And in those days, it was okay because lawyers were out there. They were warriors. But yes, I had the opportunity to do that. And also, for whatever reason, from the very beginning, he had me representing him. See, people were suing him all the time. And lawyers loved to take cases against him to show off how smart they were. They could beat Melvin Bell. Everybody wanted to, out-litigate Melvin Bell. So I was representing him all the time. And it was great fun, too, because, we'd go to a deposition and I'm his lawyer sitting next to him. And I have to try to instruct the witness not to answer it. So of course, he would not listen to me. I'd say it for the record. I'd say I instruct the witness not to answer the question, but he'd say, "Go ahead, say I want to answer it. I'm the answer." But anyway, it was it was very. She wants to say
yesterday. You hypothesized about what it would have been like if you had stayed together working.
Oh, well, I have often done that. She says I have thought about what it would have been like had we stayed together. But actually, I think it would have been difficult because another subject, but it would have been difficult because he was so uncontrollable. But yes, he was never interested or able to come about with solutions. Never. And I sat through so many negotiations with him. I remember from the very beginning, being involved in these things where a solution seemed to pop out for me. It was very obvious what ought to be done. And I would try to explain it to him, and he didn't like that. He didn't want to bring it to an end. He was having too much fun. And he made much less money than he should have made because he wasn't very effective doing this stuff.
Well, he put fame in trying the case is way ahead of anything to do with economics, right? He was kind of of the view that, hey, I'm enjoying myself in court. I'm getting in the newspaper. Who needs to worry about money? Of course, the other partners in the firm were probably not too happy about that. Right?
Well, in his firm, and when I was a partner, he and I had 3 other partners. They were just happy to be, sucking on hind tit or whatever, benefiting from Mel Belli.
On his coattails.
On his coattails. They weren't working very hard.
Belli was having fun with all his
Belli, yes, of course.
Time and money.
He didn't care about money. He didn't care that much about money, although he spoke to that issue, but he was really more interested in having fun.
Yeah.
So, he ended up in bankruptcy. So the older I get, and now I'm 84, he died at 88. The older I get, the more comfortable I am with the idea of putting together some kind of museum, some kind of television show, some kind of movie. I don't know what the hell it's going to be. But the thing that's happened is over the years, especially with Susan, since she got here, I'm beginning to feel more and more, as she will continually tell me, that it's going to be more my show than his. I'm going to use him as a stepping point. But, it went on to...
he was a part of you and still is.
Yeah.
He really developed into a much more dimensional person than he could have ever.
Well, yeah, for all those, 33 years, whatever the time I had with him. And I was looking at yesterday, again, down in the basement, he was writing about, and he had articles about his big cases. And interestingly enough, so many of those big cases were cases that he had the client, but he would call me towards the last 10 or 15 years of his career. And we would, I had Elizabeth and people like that, brainiacs, who would draft the pleadings and do stuff he could never do. And at first he didn't want to recognize it, because I think the first time I tried to do that with him and her was at Bhopal. And Bhopal was probably in the early 80s. I don't remember.
That was big gas spill. That was that big spill of gas in, was it Dow Corning? Was it the Dow company?
It wasn't Dow Corning. It was, I'll come up with it in a minute. But it was in India, Bhopal, India, where it occurred. I'll think of it in a second. But he actually went to India and set up a table in Bhopal where he sat and signed up Indian people who were affected by this explosion, whatever the hell it was.
It was Union Carbide.
It was Union Carbide.
The Bhopal tragedy was Union Carbide.
Yes. Yeah. Yes. And he wasn't able to figure this out. And actually, he and the people that were working on the case, other lawyers in the United States, with him, they got an offer of something like $300 million or whatever the hell it was, but they turned it down and they ended up with nothing. And finally, some Indian lawyers may have resolved it, similar to the experience I've had in more recent years in China, where the
I put it up big just to put the story up. This is the tragedy.
Oh my God. Wait a minute, I saw it for a minute. Oh, there it is. Good for you. You're so fast with this stuff. My God. And Union Carbide, yes.
Well, it looks like Dow Chemical might have been it too.
Maybe so. I just saw that. Yeah. We brought him a draft complaint as a class action to sue Union Carbide, and he liked it, but he didn't do it. He tried doing it the old-fashioned way. Yeah.
I mean, it's an interesting comparison because you could say these tragedies are kind of inevitable in an industrial society, And it happened in Russia too, right? The nuclear disaster was probably far worse in many ways. I mean, that was local. That was more localized. The nuclear disaster that happened in Russia, that really did affect a lot of people, even beyond the local area. Of course, no one could sue in Russia because Russian law is what it is. But India was a U.S. company that was in India, so it took guts on the part of Belli to decide to go there. But you might say the way he did it was not
the way he did it was not effective. But of course, India had a legacy of English law, common law, from the time it was under part of the Commonwealth. An interesting, a similar situation I had in Cyprus. Cyprus had English law, and it was so funny. You go to Cyprus, and it's India too, and you have these barrister type guys trying to look like they're in England, and they had that kind of system. But so he had that was as big a case as he could have ever have had, but he didn't know how to handle it. And actually, I remember something else. He had told me that there had been in Texas, some Texas explosion. This may have occurred before. I was there in the 50s, maybe or 40s. I don't remember. That he said it was just too big, just too big. He had another one over in Port Chicago, explosion of a ship. They were loading up with armaments or something. And he thought that, in those days at least, that cases could be too big. Yep. But we had a little bit of a taste of that in 9/11.
Right.
When Ken Feinberg had to come in to resolve the deaths of 3,000 people because it was too big. It was too big then for our court system. Now our court system could handle that kind of case. But it's so interesting. So you have these lawyers running around trying to, as you say, negotiate or litigate, whatever. But when it's too big, they have to walk away and turn it over to some administrative agency or some mediator or some person given particular powers. And I will say this too, in the book that Jonathan Witt wrote, Patriots and Cosmopolitans, where he has this huge chapter on Mel Belli and Dean Roscoe Pound of the Harvard Law School, how they tried to rescue us from administrative law and go to litigation, because prior to that time, most problems involved workman's compensation, and there was a administrative remedy and an amount fixed by legislators. So they went to litigation. So then with the success that Mel had and lawyers around the country, Mel compiled something called Modern Damages, and I have it up here. It's a 2-volume set of saying, if you lost an arm, how much is an arm worth? If your knee was the damage, how much is a knee worth? And whatever it was. So all of a sudden, they started listing these injuries or deaths and how much they're worth, because that's all you could do is get money. So what Jonathan Witt, the author, reflected on was the fact that so they took us away from the administrative system. They took us to the courts, which was great. But then they started compiling all this, and it was really going right back to the administrative system.
How much is a death worth?
How much is a death worth? And Jack is putting up here, there's the book, Patriots.
Yeah, there's the book, the Hidden Histories of American Law. But his big point is that this stuff zigzags back and forth between letting it be more case by case versus letting it be more of a administrative, an arm is worth this and a leg is worth that, and we're going to simplify things, right?
Right. And the last chapter, there are 4 chapters in the book, but the last chapter is Roscoe Pound, the dean, and Mel Belli, the lawyer. And it's, let's see, go to the 4, there it is. The King and the Dean, Melvin Belli, Roscoe Pound, and the Common Law Nation.
Right. That's the chapter to read.
That's the chapter to read, and that's what I'm talking about. Now, but somebody sent me a week ago, who the hell? Oh, I think Peter Haley sent it to me, or somebody, an article that appeared in, another law review, where the guy, I don't know why he'd waste time writing this, but he claimed that it was Roscoe Pound, but it wasn't really Mel Belli. It was Mel Belli a little bit, but more than that, it was Sam Horowitz, who was a lawyer in Boston, who was one of the founders of NACA, the predecessor to predecessor to ATLA and AAJ. It was Sam Horowitz that was the guy, but it doesn't matter. The fact of the matter is, it's the story and the transition from one concept, administrative law, to the litigation and back to, in a sense, administrative law, and how these things are best. And even now, you go to court and somebody will say, well, how much did they get in whatever, some other case?
Right. Right.
Yeah. So we're kind of going back in a way to the administrative law aspect. Certainly with the mediators, we're going back. But that's okay too, right? That's it. Because I'm never a great believer in punitive damages and all that kind of hooray stuff. All right, Jack.
Bob, what's the final point we want to make on this, which is lawyers can certainly become better negotiators, and probably judges can assist lawyers to some degree, but they often don't want to do it because they think it somehow is beneath them, right?
Right. And it was just a couple of weeks ago that I had a juxtaposition occur in two cases that I'm dealing with, where one judge made it clear that a federal judge, where his objective is to clear the calendar, resolve the case. The other judge says, I don't resolve cases, I try them.
Right.
So you have these conflicting views of what a judge is even supposed to do. And they take these federal judges when they're appointed and they send them to school to teach them what their job is, but they don't even learn. So I was so taken with this in two cases that I have, that two different federal judges are taking totally different positions as to what the hell their role is.
You gotta invite those judges into your MBA, JD class on negotiation and add their learning to the mix. I think that's a brilliant idea to end
They
on.
would love it.
They would love it.
Yeah.
And they would get a trip to New York to boot when it's COVID-free in 2022 or so.
Yeah, right. We're still
Okay,
alive.
Bob, take care.
All
See
right.
you soon. Bye-bye.
Tune in next time on The Valley Current.